The Department of Justice has an enduring legacy of taking on the biggest and toughest monopolies in history. This includes historic cases against Standard Oil, AT&T, and Microsoft. We have a system of laws that say competition is what should result in benefits to consumers. Competition is what should result in benefits to entrepreneurs. We just want to make sure that there is an open, fair playing field for all competitors, including Apple.
Good afternoon and welcome to Washington Post Live. I'm Kat Zakrzewski, National Tech Policy Reporter here at the Washington Post. And I'm joined today by Jonathan Kanter, the Assistant Attorney General for Antitrust at the Department of Justice. Jonathan, thank you so much for being here with us today at Post Live.
Thank you, Kat. It's wonderful to be with you.
Well, thank you. And we want to dive right into the news today because DOJ has a big announcement. For decades, there's been concern about consolidation in the healthcare industry, something you raised in a recent speech. Can you tell us a little bit about what DOJ is doing to address this?
Yes, today we are making an important announcement regarding our healthcare enforcement program. We are announcing today a new task force to take on healthcare monopolies and collusion. We're calling it the HCMC. And the purpose of this task force is to ensure that we are taking a whole of division approach as well as a whole of government approach to ensure that we hold monopolies and bad actors accountable for violations of the antitrust laws in the healthcare space. There are three animating principles. First, and this is extremely important, healthcare in a post-industrial economy is different than it used to be. No longer do we just have markets where you have separate lines of commerce with doctors or a hospital or insurance company. Today we experience healthcare as platforms. The platformization of healthcare has resulted in multi-sided giants, intermediaries that have a coordinated stack of businesses that flow together, including payers, including providers, including PBMs, claims processing, banks. These are multi-sided giants that are accumulating assets at an alarming rate and are becoming the new intermediaries and gatekeepers of our healthcare system. And it's really important that we adjust to market realities and make sure that we have not only the resources devoted to addressing these concerns, but have the expertise devoted. Second, we need to think about all of the resources and tools that we have available. And so at the Antitrust Division, for example, we have an important and effective civil and merger program. We have a monopolization program. We have criminal antitrust enforcement against cartels and collusion. We have a deep bench of experts, including economists and data scientists. We need to bring all of these resources to bear to ensure that we're addressing the market realities as they exist today. Finally, we need to have strong policy and a strong policy voice. The Biden administration has pioneered a whole of government approach to antitrust enforcement. And this means working across agencies throughout the government to ensure that we are coordinating to bring all the competition tools to bear throughout the United States federal government. And we are doing that through the executive order from the Biden administration, and in particular, our focus on healthcare. And so today's announcement essentially explains that we are upping our game. We're going to elevate the importance of healthcare antitrust enforcement. It is among our highest priorities because this is not just about dollars and cents. Healthcare is not just about making money. It's about lives. When you ask people what keeps them up at night, affording healthcare is too often at the top of the list. Making sure that doctors have the ability to provide the quality and level of care necessary to take care of our loved ones. These are real issues that affect real people, and we are organizing ourselves to make sure we can meet that moment.
And you talked a little bit about this moment and the platformization of healthcare, but can you tell us a little bit more about why now? Why in May 2024 the DOJ is taking this focus?
So we have to learn and we have to grow as an agency. And so one of the things that we have done, we do extremely well at the antitrust division, is we understand markets. We understand how markets function. And so that means when market realities start to shift, we need to make sure that we are adapting to reflect those market realities. And so when I say the platformization of healthcare, what I mean is that you have these massive intermediaries that are effectively multi-sided markets. They are on one end intermediating doctors and healthcare providers and nurses. We're moving to a world where physicians are no longer small business owners, but they're becoming employees of companies that also own health insurance companies. We're seeing the role of PBMs who interact with pharmaceutical giants. We're seeing healthcare insurance companies buying up at an extraordinary clip actual healthcare provider, doctors groups, physicians groups, emergency room physicians, nursing groups. This is changing the landscape of healthcare, and all of this is being done against the backdrop of a rich ecosystem of data that is used to increasingly make algorithmic decisions about the course of care and billing. And so we have been dealing with healthcare issues at the antitrust division for over a century. And so the idea of taking on healthcare giants is not new. But what is new is the post-industrial economy for healthcare is shifting, and it's shifting right beneath our feet. And so we believe it's important to adapt in real time.
And some of that strategy that you just laid out of companies buying up these businesses, doing this kind of vertical integration of buying up other companies in the same sector, it brings to mind United Health, which my colleagues just did a story on. And I wanted to ask you, I mean, since the cyber attack, some lawmakers have raised concern that the size and scope of that company represents a national security threat. Do you agree?
So I can't talk about specific companies or specific investigations, but I do, want to say more generally that monopolies and concentration of power don't just create risks to consumers in terms of higher prices, or in the case of healthcare, more expensive healthcare and access to life-saving treatments and medicines. But it is a resiliency risk. Our ability to succeed as a country, our ability to take care of our people and our loved ones depends on having a healthcare system that is accessible and that's affordable. And when certain large entities are controlling so much of our healthcare decision making, our healthcare system, whether it's at the insurance level or at the doctor level, or the provider level, or the data level, it creates often sitting ducks for cyber risk, and it can often create massive risk of failure, central points of failure, and it can also create very strong entities with deep incentives to put profits ahead of people. And so, whatever that company is, or those companies are, it's important that we follow the facts and the law to ensure that we are addressing monopolization as when we see it and when we believe that the antitrust laws support action.
And given these challenges that we're seeing in healthcare today, you've mentioned a few times insurers buying up physician practices. Under current antitrust law, do you have the tools you need to address and at times stop those types of deals?
So we are a law enforcement agency. Our job is to use the tools that Congress provides us. The Congress, in its wisdom, going back to 1890 and then again in 1914 with the Clayton Act, and then multiple times thereafter, wrote antitrust laws that are designed to ensure that our economic liberty is protected from concentration of power and illegal monopolization. And so those tools are very powerful and they're very effective. And we need to use them to their fullest effect when the facts and the law demand action. So the short answer is I do believe that the antitrust laws as they exist today are certainly essential to ensuring the economic freedom for all aspects of our economy, including healthcare. Obviously, Congress has the right at any time and should exercise its judgment and wisdom to clarify the antitrust laws or amend them. But as we sit here right now, I think there is a rich history of antitrust law enforcement that deals with exactly the kinds of problems that we're talking about. We're talking about gatekeeper monopolies, platform monopolies. We're talking about consolidation of intermediaries and choke points that can increase the power that small number of companies have over the lives of everybody. And I think that is certainly well within the ambit of the antitrust laws, and we will take action when appropriate.
And I want to turn now to some of the active cases that the DOJ has. We recently saw closing arguments in the Google search antitrust case, one of the most consequential cases that the US government has brought against the tech industry. I wanted to ask you, if the judge were to rule in DOJ's favor, would you pursue a breakup of Google?
Yeah, so again, I can't talk about specific companies or specific cases. I will mention just briefly that I'm extraordinarily proud of the team at the Antitrust Division at the Department of Justice who litigated that case professionally and with great skill. And obviously, we have deep respect and deference to the judicial system, and we'll allow that process to play itself out. More broadly, not speaking in context of any single case, I think remedies are a challenging question when you're dealing with large-scale monopolies that have massive control over so many parts of our lives. And I do think it underscores the importance of making sure that we're addressing those problems before they get so massive that it requires extraordinarily invasive relief. I've said before that all options have to be on the table with respect to antitrust enforcement. And if we have a monopoly where that has conflicts of interest, or where the remedies to control or regulate their behavior would be so difficult to implement, then we have to pursue structural remedies, which have been traditionally, particularly in the merger case, the most common form of antitrust remedy. But each case needs to be looked at on its own merits.
And I wanted to ask you, I mean, you mentioned how proud you are of the litigation team in this context. This is, one of the first of many tech cases that has gone to trial. Are there any lessons that you've learned from this experience that might shape how you pursue litigation in future tech cases?
We're always learning and we're always adapting. I think we need the humility to make sure that we are constantly striving to make ourselves more effective. I think the team did an incredible job, and I think we learned a lot from that process, just as we do in any case. I think there's some interesting things that I would point out. First is, we have built and we have a state-of-the-art litigation team here at the Antitrust Division. That's something we've invested heavily in through our time over the last 2.5 years. That includes the existing staff here at the Antitrust Division. We have the most talented antitrust lawyers in the world, including many lawyers with rich and deep trial experience. We've added to that bench by bringing on almost 25 first-chair trial lawyers. These are experienced trial lawyers who have tried dozens, if not hundreds, of cases, who have litigated criminal and civil cases, many of whom have been in other parts of the Department of Justice, including U.S. attorneys' offices. We also understand that facts are really important and market realities are really important. And in our cases, just as we have recently, thinking about how we put on witnesses, but also how we consider expertise. For example, we continue to rely, as we should and will, on certain kinds of economists and IO economists, but we're no longer limiting our expertise just to a narrow range of experts. And so as our cases increasingly involve deep technological questions, consumer behavior, we are looking to behavioral scientists, we're looking to industry experts, we're looking across the continuum to make sure that we can not only understand how these technologies work and how people respond in the real world, to conduct, but also making sure that we are developing a stable of experts and expertise so that we can explain that in an accessible fashion to courts.
And I wanted to also ask you a bit about the Apple case, which obviously you brought earlier this year. That case really, takes aim at the iPhone ecosystem. And so for users, if you were to win this case, how do you think our iPhones would change?
Yeah, so those are questions that ultimately will be litigated before court, and so I'll defer to a court with respect to one, liability, and if appropriate, remedies. But I think remedies need to be focused on competition, focus on preserving the competitive economy so that consumers can get the benefit of lower prices, including devices, so that consumers can get the benefit of lower prices and more innovation with respect to apps and services, so that entrepreneurs and developers can have access to an ecosystem of users in a manner that's affordable, and so that there's choice, so that they're more than that we don't have monopoly choke points over distribution platforms that are critical to not only the free flow of information and ideas, but to how we function in our daily lives. And so those are important values that we seek not only to preserve in any antitrust case that we bring or in any remedy that we pursue, but we actually believe that competition can make that better. I think one of the beautiful aspects of our country is that we have a competitive market-based economy. And when companies are competing in a full-throated way, it's a wonderful thing. It leads to innovations that we couldn't possibly imagine sitting here right now. It leads to things that were once expensive becoming affordable and accessible. And it leads to a diversity of viewpoints and ideas, which is the beating heart of a democracy where we depend on free speech and access to information. And so those are values that go at the heart of all of our cases, and certainly all of any remedy that we would pursue in any of our litigation matters.
And you mentioned we need to see what a court decides. Obviously, that takes quite some time in these cases. We're looking at an election year. None of us know what the outcome of that election will be and whether you will have this job a year from now. How are you thinking about that and where these cases go if Biden does not win re-election?
So yeah, I have the luxury of being an antitrust lawyer, enforcer who gets to sit in the office, keep the head down, work with an incredibly talented group of people. And so my focus is on what are the cases that we have now? What are the investigations we have now? How can we make sure to manage those in a way that's efficient, effective, and accurate? And then I'll leave things outside of my control to others.
But does that mean the companies can just kind of play a waiting game in this instance? I mean, the Biden administration has taken this very offensive posture against the tech industry. Is it a matter of just waiting out the clock in these cases for either, your successor to not continue them or for a court to block them?
Those strategies are up to companies. I think waiting would be at their own peril. At the end of the day, we're not going to wait. We're going to bring cases when we believe it's the right thing to do, and we're going to move to bring cases to litigation as quickly as we can so that we hold companies that we believe are engaging in wrongdoing accountable, and that's all we can do. But I will point out that the movement toward more stronger, more effective antitrust enforcement is not something that neatly sits in any one area of the political continuum. One of the things that has been remarkable to me is that there is broad public support and broad support across all aspects of the political spectrum for the work that we're doing. And I think that deep appreciation for why we want a competitive economy, a diversity of viewpoints and ideas, why we need the ability of, for example, farmers to get a reasonable return on investment for their livestock, why we need affordable access to healthcare, why we need a supply chain that is resilient, and the ability for entrepreneurs across the country to invest. All of that is front and center for us, and it's also front and center for the public. And so I think we have reached a turning point in antitrust enforcement, not because we as enforcers not just because we as enforcers believe it's important, but because the public is demanding it.
Given that public demand, how do you explain the funding cuts that we've seen from Congress to the antitrust division's budget?
Yeah. So again, we have been traditionally under resourced over the last 30 or 40 years. Sitting here today, we have far fewer people than we did in 1979. But I would never count out the antitrust division. This is a group of an extraordinary people, professionals who regularly punch above their weight. I am pleased that Congress has provided us with additional funding since I started. And so, relatively speaking, we are continuing to grow and our funding is moving in at an upward trajectory. I've said before publicly and that it is important that we are adequately funded. We often have in any single investigation more lawyers on the other side of just one investigation than we often have at the entire antitrust division. So we're not intimidated. We will fight for the public, and we will do so in a way that I think will be successful. When we pick our battles, we will fight to win them because we believe enforcement is good, not just for the public's wallet, but for our democratic values and ideals. But ultimately, Congress needs to make its judgment about funding, and we defer to that. We appreciate the money that Congress is willing to provide us to support the work we're doing, and we will continue to keep at it.
And just on this question of resources, timing, I wanted to ask you a little bit about what we're seeing right now with the Google case. As we're in the closing arguments for Google, we're also seeing Google push into what they're calling SGE, a generative search experience, and moving into AI and really changing the way we search online. And it raises the question, can these cases move quickly enough when the technology at these companies is changing so rapidly before our eyes?
Yeah, the short answer is I do think they can. I think it's our obligation to make sure that we are moving quickly to address these issues as close to real time as possible. But I also think the principle of antitrust enforcement goes a long way. The fact that we are litigating cases at a rate that we haven't seen in generations is itself important. So until and it was the previous administration that brought the Google case that we just, or at least filed the Google case that we just litigated. That was the first real Section 2 monopolization case that the Department of Justice had brought since it filed US v. Microsoft in 1998 or thereabouts. We've seen almost none during that period, and that's I think, a startling fact. It means that a whole area of antitrust enforcement had largely gone ignored, and but not anymore. Now we are bringing, we have more active monopolization cases right now, both civil and criminal, than total over the last 20 plus years. And that number, continues to grow, and our sophistication in bringing those cases continues to expand. And so I think the more we bring cases, the more we will induce compliance, the more we will generate remedies. I think it's also important to recognize that antitrust cases focus on forward-looking remedies. And so whatever the case might be, this is a principle that was established in the US v. Microsoft case. The remedies have to address competition as we find it today, not as we may have found it at the time that the anti-competitive conduct started. And so we need to look forward and make sure that competition is protected, not just to remedy destruction of nascent competitive threats or emerging competitive threats in the past, but to preserve the ability of those emerging competitive threats to have their full-blown effect.
And so, I mean, in the case of Google, we're looking at the investigation started more than 5 years ago. The Trump administration brings the case in 2020. It goes to trial last year. We get a decision sometimes this year. It's quite a long process. In Europe, we've seen the recognition that they need more specific competition laws to deal with these types of tech threats that move very quickly. I mean, do you think the US needs to reconsider whether it needs new antitrust laws to specifically address the tech sector given these timing constraints?
Yeah. So there have been a number of proposals over the years, including a bill authored by Senator Klobuchar that we were vocal in our support of at the Department of Justice. And but ultimately, that's the prerogative of Congress. I think if it, in its wisdom, wants to clarify the antitrust laws or expand the scope and reach, that very well may be a good idea and welcomed by us, but ultimately that's a decision that is left to Congress. We here at the Antitrust Division can offer technical assistance, and in the case of, for example, that legislation, offered our full-throated support. Um, but when and until there are new laws, our obligation is to enforce the laws that we have today. And I do think that they can be effective, even if there are opportunities for improvement. And I think what you hopefully have noticed in our cases is that we are not just bringing more of them, but a number of our cases are going to trial faster than they used to. And so, for example, we have a case, another large tech case that was filed in January 2023 that's scheduled for trial in front of a jury in September 24, which is a very fast turnaround.
And I want to turn gears now to artificial intelligence because you just announced a new workshop on competition and artificial intelligence. And so can you tell me a little bit about what are your biggest concerns when it comes to competition in this emerging market?
Yeah, so I think there are a number of dimensions that we have to think about as enforcers. First and foremost, to make sure we understand the technology. So when you have new realities in the marketplace, it changes the economics, it changes the decision making, and it changes how products and services are built and brought to market. And so, it's no surprise, at least to me, that some of the most significant antitrust cases in history came at times of major technological inflection. And so, whether it was creation of factories and railroads during the Gilded Age and the industrialized economy, or the telecommunications expansion that led to AT&T, or the PC revolution that led to Microsoft, or now the internet revolution that led to companies like Google, those are pivotal points and important inflection points where antitrust importance is perhaps more important than ever, or more necessary than ever, to ensure that those markets remain competitive and that incumbents aren't able to lock out rival and innovative technologies. I think AI may present many of the same kinds of questions and challenges. These are technologies that are built on massive data sets often. We have to think about everything, from the chip down to the end user. And so whether there's consolidation in the hardware, whether there's consolidation in the data sets, whether there's consolidation in the software, and then obviously how the technology is used. And so if algorithms and AI are used to set prices and to coordinate, it may mean that a lot of things that we thought were once difficult to do in the analog world in terms of price fixing and collusion can become automated and programmatic and widespread. And so we have a lot to do to make sure we understand those technologies and to make sure that we are bringing the appropriate cases to ensure that the law, which is often made through litigated court decisions, has the opportunity to keep pace.
And we only have a little bit of time left, but as AI becomes more front and center, Microsoft has been striking deals with companies all over the world to provide AI systems. And you previously represented Microsoft as a lawyer. Does that present a conflict of interest as this becomes more of a forefront issue for the Department of Justice?
So the department has rigorous conflict of interest rules. I adhere to them, but let me also take a step back to. I think anybody who knows me would understand that I believe very much in our mission. I care deeply about antitrust enforcement. We are hard at work enforcing the antitrust laws in every aspect of our economy. I'm now 2.5 years plus into this position, and I'm thrilled and honored every day to work alongside um, my colleagues at the antitrust division, and I think that the work we're doing is incredible. But if I've been I think if you ask any company in the ecosystem whether they think I'm going to be soft on anyone, I think the answer you'll get is that this antitrust division is as tough as any we've seen in generations, and I think that I'm proud of that reputation, and I'm proud of the work we're doing.
Well, unfortunately, we're just about out of time and we'll have to leave it there. Thank you so much, Jonathan, for joining us today at Post Live.
Thank you, Kat. It's great to be with you.
And thank all of you for joining us as well. You can catch up on more of our Washington Post Live programs at washpostlive.com. Thank you.